Well, Mr. Sloven, you know the drill by now. Could you do a sound check?
Sorry, push the button. Can you hear me?
Yes, thank you.
Very good. Ms. Conroy?
Justice Appel, can you hear me?
Yes, thank you.
Ms. Conroy, you may remain standing and proceed.
Thank you. May it please the court, counsel. My name is Mary Conroy. I'm with the Appellate Defender's Office, and today I'm here representing Patrick Barrett, Jr. Here, the district court erred in denying the defendant's motion for a new trial after confidential records were disclosed to the defense on remand. In a previous appeal, the Court of Appeals found that medical records that Mr. Barrett had requested the district court erred in not disclosing those to Mr. Barrett. And in reaching that decision, the Court of Appeals found that these records had exculpatory evidence and that there was a compelling need for the defense that need was outweighed any privacy interest that the child in this case had. It's our position today that under any standard that has been discussed by the parties that Mr. Barrett should receive a new trial. However, Mr. Barrett's asking this court to adopt a harmless error standard, specifically a constitutional harmless error standard because of the rights involved in this case. Here,
as you read the district court's ruling, what standard do you think it applied?
I think that's a good question because it's really not clear. The district court mentions a ton of different standards on what in its short ruling, and I can't really fault the district court here because it's not clear. I mean, that's why we're here today. Is the case law is not clear what the standard it should have applied is. I guess the closest I think is maybe a weight of the evidence standard, but it's really not clear, Your Honor, what standard the district court did apply.
Counsel, doesn't the district court say the nondisclosure was indeed harmless, and even if the jury had the exculpatory evidence, it would not alter the weight of the evidence insofar as to grant a new trial? Was the district court applying a harmless error standard there?
I don't think so. Based on all the other language, that non-disclosure is harmless statement is really conclusory. There's no finding or anything in the court's actual ruling that shows that it actually considered whether or not this is harmless error. And I think this record shows that it is not harmless error. We have a child witness who's the only witness against the defendant. The disclosed evidence is impeachment evidence, which this court has noted when there is only one sole essential witness for the state. Impeachment evidence can make the difference between acquittal or a guilty verdict on that witness. In addition, we have evidence that would have changed.
Counsel, what evidence specifically do you point to as the evidence that would have flipped this?
I think it's hard to say that there's one piece. I think all of them, are arguably could have flipped this, especially given the outcome of the verdict where the jury did acquit Mr. Barrett on an account that the victim testified happened. So, but I think it's really relevant, and it shows how important these records are. The fact that at trial the victim said that he didn't disclose, and that came out, that he didn't disclose though he had been in therapy for several years and during the time of the alleged allegations. But what it didn't actually show is that he had been asked multiple times by different people whether or not he had been sexually abused. And I think that's a very different standard of, yes, I didn't bring it up on my own, but he was specifically asked by two different people and by one person at various times while the abuse was alleged to have occurred, and said that he was not being abused. He denied that anyone had touched him in a way he didn't like. He denied seeing any other people naked or any other people seeing him naked, all of things that he later testified to happen. So I think that's a critical piece. I also think the piece that plays into the defense's main defense here, which was the custody situation, his relationship with his father is super important. The medical records that show, I mean, just 8 months prior to the allegations, that he's making comments about wanting to seek revenge on his father and get even for with his father. I think those are incredibly relevant and incredibly impeachment. If the defense had used that or had the opportunity to have that at the trial, I think with effective cross-examination that could have made the difference in this case. In particular, like I mentioned, because the jury's verdict necessarily indicates that they didn't credit some of the child's testimony.
Should we use the standard foreshadowed in footnote 3 of Niederbach that you get a new trial if the evidence that wasn't presented to the jury probably would have changed the outcome?
I don't think so, because I think that's more of a newly discovered evidence standard, and I don't think that's appropriate here. I do think also that language comes from Ritchie, which is sort of confusing because it is a Brady case, but it's before Bagley. If you're going to stick with the language in the footnote from Niederbach, I think what it really is suggesting is a Brady standard. And it does, I think, cite specifically Brady in that footnote, if I'm not mistaken. And that's not the standard in Brady, obviously, this court's aware. It's a reasonable probability, but if the evidence had been disclosed, the result of the proceedings would have been different, which is a less strict standard than probably would have changed the outcome.
Well, now that you've mentioned Brady, tell us whether the Brady standard is the best standard or why we should depart from Brady. The argument would be, well, when the prosecution doesn't release evidence, the Brady standard applies. Here, it wasn't quite the prosecution, but it was the state. I mean, the judge is put in the position to be in the state. An argument can be made that, by analogy, the Brady test makes the most sense. What's wrong with that?
I think it doesn't recognize what this court has recognized is the defendant's right to put evidence that might influence the jury's determination of guilt in front of the jury. Also, this court has acknowledged that when relevant evidence is excluded for any purpose other than enhancing the truth-seeking function, that the danger of convicting an innocent defendant is increased. And so we are talking about evidence that was known, that the court looked at, and so I do think that there should be a higher standard. And when we're talking about harmless error, we're talking about evidence that has permeated the trial. And certainly I think this evidence qualifies as evidence that, or an error that that influenced the trial. It influenced trial strategy.
Counsel, would you agree that the Brady standard is similar to our standard for newly discovered evidence when we send back on that basis? And so, I mean, are you advocating that we kind of rewrite that also to the harmless error standard?
No, I guess my understanding of the newly discovered evidence standard was that it probably would have changed the result, which I think is higher than the Brady standard. I think if we're looking at those two standards, then the Brady standard is more applicable between the two because we have a more similar situation where there is evidence that should have been disclosed that wasn't, and we're trying to determine how that evidence affected the trial. So between the two, I guess, I don't think you have to look at newly discovered evidence at all because I think if we're talking about those two standards, Brady is more applicable to this situation.
So I gather you're saying this is really should be treated like an ordinary evidence question, namely, set aside the structure we have with the court doing in camera and so forth. But if a criminal defendant offers evidence that's objected to, and it's excluded by the trial court, and that turns out to be wrong, the standard on appeal, assuming we find that it should have been admitted, is
Harmless error.
Yeah.
Right. That's exactly our argument, Your Honor. We argued for constitutional harmless error based on the fact that this statute is based on the defendant's constitutional rights to receive those records if they actually do have the right to receive the records under the statute, if they meet the thresholds and the balancing test. So yes, but yes, we would have the court treat it as an evidentiary error that's preserved, which this is.
Well, I'm sorry, wait a minute. I want to make sure I understand what you just said. The defendant gets these documents based upon a statutory right? I mean, it's not a constitutional right.
Well, I think cash-in, which is what the statute is based on, is we can't discount the court's decision in cash-in, which this whole statute is based on the fact that the defendant has a right to put evidence that might influence the jury in front of the jury for their determination on guilt. And so there is underlying constitutional issues with this statute. Now, I recognize that the court in Thompson has said that the statute is constitutional and adequately balances the privacy interests that the child or the victim of the child might have with the defendant's constitutional rights. But there is a constitutional right for the defendant to have this evidence if he meets the statutory test. So I don't think it's purely a statutory issue. I think there's an underlying constitutional issue with the defendant's right to put this evidence before the jury, with its right to present a fair and full defense, with its right to a fair trial. All those compulsion, confrontation, all of those constitutional rights that a defendant does have are wrapped into whether or not the statute is applied correctly. If the statute is applied correctly, then I don't think we have any of those constitutional arguments based on the court's decision on Thompson. But when
so can I want to get your take on this. So in your view, does cash-in live except for the process that it changed, where instead of counsel looking at it, it's the judge looking at these documents or at these records?
Right. I don't think the court's decision in cash-in is completely invalid because the legislature came back and said, actually, we want to provide greater rights for people who have sought mental health treatment. I don't think that changes the underlying analysis of cash-in on whether or not the defendant has a right to put evidence before a jury. And I think this court in Thompson says, like, the defendant has that right to put evidence in front of a jury that might determine guilt or innocence. So does that answer your question?
Yeah, I think so. But I thought in Thompson we were relying on the statute, saying that the statute properly balanced those things.
Right. I think you are, but you are also looking at the defendant's, the reason the statute exists is because the defendant has this right. So it's a way to protect the defendant's right. I'd like to talk, I think, a little bit about something else that the evidence showed, was that there might have been another suspect. And I think that's really helpful to the defense had they known it, especially when looked at in the defense theory of whether or not this was a custody determination, whether the allegations were fabricated. As a defense attorney, they could have determined, and that could have changed their strategy on putting forth this defense, specifically that maybe arguing that the child was in fact abused, and that's why he was able to give some detail on what had happened in the sexual acts, but that he had picked his cousin instead of his brother for whatever reason, whether or not he didn't feel comfortable actually accusing his own half-brother, or whether or not it was because his half-brother had already been out of his father's home at the time due to his own legal problems. This is extremely relevant. There's no indication that the defense knew about this. And even if they had maybe known about the fact that the half-brother was facing criminal charges of sexual abuse, it's very easily that they could have discounted that because they didn't have the essential facts necessary.
Ms. Conroy, on that issue, doesn't that suggest you need to apply a more of a newly discovered evidence type of standard review? Because now we're talking about sort of an alternate universe. In other words, maybe the defense would have picked a different theory of defense, and maybe it would have been a different trial. And in that context, isn't it pretty hard to apply a harmless error standard?
I don't think so, especially when we're looking at whether or not, I mean, I guess that the court at some point has to weigh whether or not that's enough of a defense. But certainly, like, this comes up in the Brady context all the time. I can't remember the case name off the top of my head. I think no, it's not. Harrington might be one of these cases where the court says there's enough evidence that shows that if there had been an alternative suspect, that would have changed the nature of the trial, would have changed trial preparation. Those are all sorts of things that this court looks to in a Brady analysis. I think, yes, the court probably does look at it in a newly discovered evidence context as well, but I don't think that necessarily means that this court has to apply a newly discovered evidence context. Oh, I'm sorry, Your Honor. Thank you.
Thank you, Your Honor, and may it please the court, counsel. Good morning. I want to start on what standard did the district court actually apply? And I agree that there are a lot of different standards that surface in the ruling. I think that it was, Justice McDermott, you were correct to say the district court found that this was indeed harmless. There's another statement on the same page, I believe it's page 4 of the ruling, where the court finds no evidence that would probably have changed the result of the trial. So I think that the district court's ruling is clear that I think it would be fair to say that the district court made its finding about the effect of this new evidence on the trial and found it wouldn't even meet a non-constitutional harmless error standard. Now, there was never a constitutional violation being alleged. There was never a constitutional claim raised. So I think that, I don't think it's necessary, whatever you find the standard to be, I don't think you need to remand for the district court to apply it. I think the district court has already made it very clear from its findings that nothing changes its view of the credibility of AF's testimony. The evidence was indeed harmless, and also it probably wouldn't have changed the result of the trial. So in terms of what the standard should be.
Well, I mean, I hear what you're saying, and it's just a kind of a complicated order, obviously. But why couldn't one conclude that, well, the standard is probably wouldn't have changed the outcome of the trial, and therefore it's harmless?
I think that you could, you could read it. I think that the court also cites Niederbach, which makes the reference to Ritchie and says that it includes that phrasing that was brought up also, that the test is whether it would. Now, the phrasing is a little unclear even in that case. It says reverse if the evidence probably would have changed the result, but affirm if but affirm if it was harmless. Right, there's a layer, an interstitial layer where the court doesn't actually give very clear guidance on what to do. So when I read the district court's ruling, to me it seems very clear that it is saying that even after reviewing all this exculpatory evidence, it has no question about whether it would have changed the result at trial under any applicable standard. I think the court is very convinced in its ruling that that would not have happened. And
Mr. Sloven. The lack of clarity in that footnote, Niederbach, because I wrote it. But if we're to follow up on Justice Appel's question, is this like an evidentiary error? Shouldn't we review the district court's ruling as we do generally for motions for new trial? Shouldn't we just apply an abuse of discretion standard or review here?
I think that's correct. That's how this court reviews the district court's ruling for abuse of discretion. There's some suggestion otherwise in the defendant's brief, but only based on the idea that constitutional issues are reviewed de novo. And again, there was never a constitutional claim here. There was only an allegation of a statutory violation. That's what it was when it came up on the Court of Appeals last time, and that's what it was below here. That's what the court ruled on. Now,
Give deference to the district court, which heard the evidence firsthand, had a front row seat for the trial, is intimately familiar with everything. Give a lot of weight to that judge's determination that this evidence probably would not have changed the result of the trial.
right, and I think that's a useful parallel to newly discovered evidence cases where we put a lot of, because there's no replacing the firsthand court-side view of the evidence as it came in at trial, the testimony of the witnesses, and the relative credibility in assessing what its impact would have been.
But normally in an evidentiary context, when we're reviewing, as Ms. Conroy points out, a refusal of the court to admit evidence, we don't give deference to the district court's refusal to admit it. We apply the harmless error standard ourselves, right?
On the question of the admissibility of it, that's entirely correct, because the admissibility of it is a pure issue of law. Now, there can be contingent facts that go into the admissibility, right? Whether the statement was an excited utterance or how excited the witness was. But I take your point. This is at the intersection of a unique couple kinds of cases. This is a case where we're asking about the likely impact of new evidence on a trial that already occurred, kind of like the fourth prong of newly discovered evidence. And it's also a case that is a claim of error based on a discovery rule, a pretrial ruling about discovery on the scope of a privilege. And as we cite in the brief, Tow's, Jones, and Struve, especially in Jones, this court said, we don't presume prejudice for claims of error in discovery rulings.
Let me offer another thought. Your brief is very, very thoughtful, as it always is, but here's, the Court of Appeals applied an abuse of discretion standard in sending the case back in the first place. So the Court of Appeals already had to find an abuse of discretion in not producing the materials. So given that, shouldn't we apply a tighter standard of review now at this point in reviewing whether those materials would have made a difference at trial?
Yeah, I think I understand the point. One of my, the thing that sticks out to me about this case is that the Court of Appeals opinion found an abuse of discretion in not recognizing particular information and still remanded because there was a part of the analysis that the district court has to do. The district court only the district court has the light of the evidence already received and what impact it might have had on the defense strategy if that had been shown, but it really wasn't, and on the evidence as it came in.
Was the trial judge consistent throughout, meaning is the trial judge that did the in-camera review, presided over trial, and ruled on the motion for new trial the same?
I don't believe so. And I think that, in fact, I am pretty certain that's not the case. But still, assessment of,
Well, let me ask this. The judge that did the in-camera review before it went up to the Court of Appeals the first time, is that the same judge that ruled on the motion for new trial on remand now?
No, okay. Your Honor. But I think that it's still important to have the firsthand evaluation of the evidence as it comes in at the motion for new trial stage, because more evidence can come in. And I think that's what in order to prove an effect on the defense strategy at trial, there can be some opportunity to prove here's what additional investigation based on that could have discovered and what would have been presented, right? But there really wasn't any proof of that here, and the reason is because the defense already knew everything. The defense had testimony from Chad that described pretty much.
Here's the problem with that is, we've seen now a number of these sort of post-Cashin cases under the post-Cashin statute, and what seems to be unique about this one, or at least what sticks out to me about this one, is this is a case where the person who made the reporter who reported the abuse, to whom AF disclosed the abuse, is also the person whose records you were trying to get. And that seems to me much less than the typical fishing expedition that we've seen in some of these other cases, where you have a victim, the victim's in therapy, and you want to get the therapist's records. Here you have a victim, the victim reported to the therapist disclosed, and now you want to find out what else the therapist was told about. Doesn't that seem more directly connected to the case than we usually have?
Well, for that portion of it, I mean, this was very broad. There were a lot of records here, and not all of them came from that same therapist. But for that therapist's records, I think that the connection is closer, but it still doesn't help establish. I really don't think that it helps establish any problem with the victim's credibility. He testified that, yeah, I didn't disclose this. I kept it hidden because I was ashamed about it. And then it kind of came out in a conversation that, where I mentioned two types of abuse.
The therapist is testifying. It just seems like there's a big chunk of the trial that maybe was missing without these records, right?
I don't think so. I think that when you look at these records, you find things that are cumulative with evidence that was actually presented.
Well, counsel, sorry, you go ahead.
Difference between the failure to disclose and an affirmative denial of the abuse. And as I understand it, there's always the argument that the victim didn't disclose the abuse during the therapy sessions. But here, as I understand it, there was actually multiple affirmative denials of the abuse upon being specifically asked about it. Isn't that right? Factually?
Well, two things. First, that testimony actually was presented in the original trial with looked at his mother, turned as white as a ghost. So wouldn't have changed the outcome. It's not new. And second, I think that the distinction between those is less clear than you might think. That the answer, when asked that question, straightforwardly, to a child, the answer no is, it's very clearly going to end the conversation and you get to avoid the disclosure. It's pretty obvious at that moment that answering yes means we're going to have a conversation about it. So if somebody has chosen to delay disclosure because they don't like thinking about it or they're uncomfortable talking about it, and he testified at length about why he didn't want to talk about it or why he didn't, what went into this delayed disclosure, why it was difficult for him to describe what happened even once he started, telling people about it. Now, there's also stuff in the records that undermines the defense theory, interestingly enough, that the defense was he must be fabricating this because his descriptions are inconsistent and he's forgetting details in some recitations.
If I might go sort of to that point a little bit, in closing argument, a big deal was made about how this boy would have had all of the detail that he had about the events that happened. And we now, through these records, have more information about the stepbrother and what the stepbrother was potentially doing. At least as I read them, there was some reference to he didn't want to talk about it. His stepbrother was coming into his room at night. He was embarrassed about it. Isn't that a viable path that the defense should have been able to go down in this case to try to put on some defense about how he otherwise might have known about these sex acts?
I've got three thoughts on that. The first is that you have to make an extreme inferential leap from what's in those records to the half-brother did any sexual abuse to AF. The second is all the Chad was an extremely defense-friendly witness, available for everything. Everything Chad knew was at the disposal of Mr. Barrett and his defense team, including these. Sean Williams was mentioned in the testimony at trial, and so there's no indication that this information couldn't have come or wasn't already available to the defense and couldn't have come from another source.
Okay, but let me push back on that a little bit. Am I right that in the therapist records, it says that he didn't want to talk about what was going on with his stepbrother? He was embarrassed about it?
He said that there was something that he was embarrassed to talk about with his stepbrother, but it wasn't implied that it was related to him coming into the room. It was just a thing about his stepbrother that he was embarrassed to talk about. And that can be any number of things. People live together. My third point is that this was never a whodunit type of case, and the theory that it's a revenge, that this is some sort of plot to help his mother get custody or revenge against his father, and so we're going to accuse the cousin who infrequently visited and doesn't visit really anymore, and now it was already presented and already rejected, and it's just so convoluted. It doesn't make sense. Why not just accuse Chad? He knew that triggered an investigation.
But if I might push back on that, I think that the boy in this case testified that he actually wanted to be near his father. He wished that he could see his father more. But didn't those records that weren't disclosed actually say that, said the opposite?
Well, that's not exactly what his testimony at trial said. He said he wished that his father hadn't given up on their relationship, that he wanted to not live with his father, but he wanted his father to want him to want something different. And I think that story comes out and this is my big frustration with this, is that when we look at these records, especially when you look at just the pages of records that contain a kernel of exculpatory information, they don't tell the whole story. Luckily, with these, we're getting enough that you can see how his relationship with his dad changes over time that actually supports what he said at trial. But we're not getting to say that this is about the search for truth. These records paint a misleading, at best, picture. I'm sorry, I see my time's expired, if I can just briefly. Thank you. And there's so much. If something contradicts that and shows and is entirely consistent with his trial testimony, it just doesn't get, and nor does the state get access to whatever Mr. Barrett said to the treating medical staff when he went to the hospital after that first interrogation that may or may not have contradicted his later trial testimony. It's the privilege here is by legislative determination is superior to the relevance of the information. And that you need to remember that when you're deciding what standard to apply, that this, at the very least, it has to be the Brady materiality, but in reality, because of the right that we're talking about here and the impact on the trial, it should be more demanding to protect the finality interest and the privilege interest. Thank you.
Thank you. I think I'd first like to start with the proposition that the evidence, or the defense got all this evidence from AF's father, and so this doesn't matter. And I think that's based on a wrong assumption. I think certainly it's obvious from the trial testimony that AF's father did provide the defense with favorable testimony and evidence. But there's no indication that AF's father would know everything that AF disclosed to his therapist at any given moment, that AF's father would know each of the notes that were that the Court of Appeals found were exculpatory, or even if he had known at one point, if he would have remembered given the time span of this. So I think that's incorrect, first of all. And I think the second piece of this, as it regards to Sean Williams, is AF's father's son as well. And the records that were disclosed show that both the AF's father and his stepmother did not think that anything was happening, and they showed no concerns when the therapist brought it up to them. So I don't think there's anything in the record that would show that they would readily disclose this information about Mr. Williams that they might not have had, but also that they might have downplayed because it was their own son. The second thing I want to...
let me, because, and by the way, your brief was excellent as well. You argue for this harmless error standard. Is there a logic to say, well, we'll apply abuse of discretion to the discovery issue, which has already been decided, settled by the Court of Appeals, and then we should apply harmless error to the evidentiary issue? Is there some logic to that, and that would avoid the problem that Mr. Sloven talks about, that you don't want to have people willy-nilly give out mental health records because they're concerned about being second-guessed by an appellate court?
Yes, I think that makes sense, Your Honor. I also think it plays into the questions that both you and Justice McDonald asked about who the reviewing judge of the initial disclosure or the initial decision under 622.10.4 is, and how that might play into their decision on remand. And I will agree with the state, it was not the same, I'm almost positive it was not the same judge in this, but many times, like in a murder, judges are specially assigned. So the same judge who said that the evidence was not assuming that we get to the same point that we are now. This judge has already looked at this evidence, thought it was not exculpatory, thought it was not material to the defense, thought it was not cumulative, thought it was available to the defense by other sources, or that this compelling need for it was not outweighed by the victim's privacy interests. And so then if it comes back to that same judge, is there a different rule for judges who have already heard this evidence and decided that it was exculpatory, which would be in direct contrast to an appellate decision, obviously, if we're getting to the point where it's been reviewed and remanded. Is there a separate rule for if it's the same judge versus if it isn't? I just don't think that makes sense.
Can I ask you a follow-up on that, Ms.
Yes,
Conroy?
Your Honor.
And that was the gist of my question, and I wasn't familiar with the answer. But in the case where, let's take this case, for example, where it is remanded after appellate review, should there be some sort of procedure to make sure that it is a different judge that rules on the remand motion, given what you just said, that if the 622.10 judge has already looked at the evidence or the records and said it's not exculpatory, et cetera, more likely than not on remand would say, I've already concluded it's not exculpatory in any event, and so it wouldn't make a difference. Should we be thinking about that issue?
I think so. I think it would be extremely problematic, and it's sort of like, I guess, I did not raise this in the brief, but it is sort of, what we're talking about is sort of when the judge considers an improper factor in sentencing, it's remanded to resentencing in front of a different judge. I think that makes sense when the judge has already abused its discretion and found that this evidence shouldn't be disclosed. I think it's entirely problematic for the integrity of our judicial system to then have that same judge be reviewing the evidence on whether or not it affected the trial, because that judge didn't think it would have affected it in the first place.
So in this case, where it was a different judge, how does that affect our standard of review of this new judge that had a fresh set of eyes then?
Well, I guess I don't think in this situation, I don't think it matters that it's a different judge. I think the standard of review should still be a harmless error review because of the nature of the offense, because of the defendant's right to put this evidence before a jury for the determination of guilt, because we are talking about injecting unreliability into the trial process. I think all of those things lend itself to and combined with Justice Mansfield's point of, to get to this point, we are already at the point where the judge abused its discretion. And so I think a higher standard of review makes complete sense when we're talking about how we got to this process and this point, and the interests of the defendant that are involved.
You may sum up.
Oh, thank you, Your Honor. For these reasons, we ask that the court remand for a new trial. Thank you.
Case of State v. Barrett is submitted. Bailiff, you may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.